live, and welcome to the Unhitching Hour, How the Law Works When Your Relationship Doesn't, Episode 7. I am Reed Aronson. I am a divorce and family lawyer here in Manhattan.
And I'm Vanessa Aronson. I am not a lawyer. I'm Reed's wife, and I'm here to listen and learn just like you.
So, like I said, the Unhitching Hour is about divorce and family law. It's trying to give some people a chance who may not know that world, or maybe heading into that world, may have a big life event that's happening, or you may know somebody who has a big life event that's happening, and just giving you a little bit of information about how the law looks at things, and sometimes may be surprising, and sometimes may be how you'd expect. But giving you those tools to kind of look and see, okay, so that's what's happening.
Great. What are we talking about today?
So today's topic. So last week we were talking. Today's topic is continuing the multi-part series on the cast of characters you see in custody cases, which I did not realize the alliteration when I embarked on that sentence.
Oh, cast of characters in custody cases.
Yes, last week.
Say that 10 times fast.
Cast of characters in custody cases. Okay. I could probably do it. Last week we talked about the attorneys for the child. And this week we're talking about forensic evaluators. So normally we start this off, or we get started pretty quick by showing everybody a case, a real case, the facts of a case. Vanessa will then sort of tease out how she would decide that case based on her own sensibilities, her own experience, her own view of what's fair and what's unfair.
As a non-lawyer.
And then I'll just tell you what really happened, and then we can discuss it. But I think because forensic evaluators is maybe so unexpected to people, I think it would help to give a little bit of background.
Oh, okay.
Before we get into the case. So a forensic evaluator, and this is in most states that I know have some mechanism like this. I'm usually speaking from a New York perspective because that's where I practice, but I know a number of states have mechanisms that are like this, if not every state. But a forensic evaluator is a mental health professional. Usually a psychiatrist, but sometimes a psychologist, but somebody with mental health training and experience, who was appointed by the court to analyze the parents, to analyze the children, to figure out as best they can their psychological needs, if they have issues, if they have particular problems, if they have any maybe mental health issues, those sorts of things, and report back to the court. And they are they're a neutral party. They're not in New York, and I believe this is the case most places. It is not somebody who is like we talked about last week, the attorney for the child. They're not there to advocate for the child. They're not there to advocate for any particular parent. They're there basically to help out the court. And while it's maybe unexpected for people, there's a good sense to it, because think about it if you're a judge, right? So you're a judge, perhaps in family court, you have these two people who come to you, they've got maybe two kids. They're obviously in conflict, because if they weren't in conflict, you wouldn't have an issue. They would just come to an agreement. And they're going to be making all sorts of claims about each other.
Okay.
Right. Perhaps, one says, well, he's got an anger problem, or well, she has terrible judgment. She's got some sort of executive functioning problem. You're a judge. You have experience being a judge. You see people a lot, but you're not trained in mental health. Right. You're not trained in psychology. You're not trained in these sorts of things. And in addition, you are limited by the fact that you're a judge, and you might have, some judges, a lot of places have literally hundreds of cases, right? I can't necessarily as a judge, or you can't necessarily as a judge say, well, you know what I'm going to do? I'm going to go and I'm going to spend, an afternoon 3 times or 4 times watching these people and doing all of that. And you're also limited as a judge in terms of the kinds of information that you're both able and allowed to consider, right? You're not supposed to, as a judge, for example, you're not supposed to say, well, let me just meet with this one party and I'll talk to the one party and I'll get what this one party thinks, right?
Sure.
Because as a judge, right, you got to be transparent. You've got to be open. You can't, it's called ex parte. You're not supposed to do that. So by appointing somebody who's training and who's, the sort of the ambit of their role allows them to do this kind of analysis in a much more comprehensive and thoughtful way than a judge really could.
Okay.
They are very common, forensic evaluators.
Okay, that was going to be my question. Is that if you were in a case, or if you were going through a divorce with your spouse and the judge recommends a forensic evaluator, is that something you should feel worried about at all?
We'll talk about that a little bit. And the answer is, it depends. It depends on who your client is and what you think your client's issues or vulnerabilities.
No, I'm saying if you're not the client, you're the spouse getting divorced.
Forensic evaluations are, as you can imagine, very they're stressful.
Yeah.
They're difficult, right? You have this person who is at some level judging you, right? Who, and who, if so yes, they're difficult, they're stressful. It requires a lot of time to do a forensic evaluation. You have to be cooperative with a forensic evaluator. You have to be, cooperative. So you spend time. The kids have to. It means that your kids are going to get sort of pulled into the whole thing. But it does the value that you get from it. Most judges in the courts will think is worth the time.
Okay.
All right.
All right.
So why don't we start off then? Why don't we go into the first case for today? We're going to have two.
We have
cases
two
today.
cases today.
Two cases.
Okay. This is becoming a trend.
Yeah, it seems that way. All right. Optimize.
Today's first case is called Markovitz versus Markovitz from Rockland County in 2020. Mindy and Israel are getting divorced and they're going to have a custody trial. There are allegations of domestic violence against both parties and allegations that Mindy has an untreated mental illness. In order to address these issues, the judge appoints Doc as a forensic evaluator to give a report. She talks to both parties, and in fact, she does write a report. Mindy clearly likes the report because she wants Doc to testify at the trial. But before she'll do that, Doc says, "Pay me first." The court order requires both parties to split the cost. Mindy pays, but Israel doesn't. And as a result of Israel failing to pay, Doc never testifies. The trial decision goes against Mindy, and Mindy appeals. And the question is, on appeal, should there be a retrial so that Doc can testify?
So,
wow.
Okay. So that's what you're faced with, right? There's a forensic evaluation. It seems to go well for one of the parties. As a result of the refusal of one of the parties or the failure of one of the parties to pay, the forensic evaluator doesn't testify, although there is the report. And ultimately, the trial decision goes against the mother who had wanted her to test, who had wanted the doctor to testify. And then she says, well, I want to do the whole thing over because, I didn't get that.
Okay, right. So I'm going to ask some questions because I have some questions. But if anyone out there who's watching has questions as well, you can put them in the live chat, in the live Facebook chat, so you can help me out a little bit. So my first question is, it's the judge who orders the forensic evaluator, correct?
Mm-hmm. Correct.
So neither party has a choice whether there will be a forensic evaluator.
Correct.
But the parties split the cost.
It depends. So in the order that the judge will issue in appointing the forensic, the judge will say who pays what percentage of the forensics fees, right? Now sometimes, of course, if you have indigent people, right, sometimes the state will end up paying for that. But in this case, right, that wasn't what was going on. I believe, my understanding is that the court had ordered that they split the cost of the forensic evaluator 50-50.
So if the judge ordered the evaluator, can't the judge order Israel to pay?
And in fact, Israel eventually did pay. But by the time that had happened, there had been a lapse of time. Mindy had asked for extra time so that they could sort it out. The judge decided, look, we've got to move forward. Time's of the essence. Didn't grant the extra time, and therefore the doc didn't testify, and that's where we are.
See, that seems totally crazy to me, because the judge ordered, we need a forensic evaluator. So, and then the judge basically said, I'm going to make my decision without the forensic evaluator. So that, I think that was bad, judge.
Well, look, what you didn't have was the forensic evaluator didn't testify, right? So it didn't actually come to court.
So did the judge
but
get the
did
report?
issue the report. Yeah, the judge would have seen it.
Oh, so the judge saw the report. So the judge took the report into account.
I can't say how much the judge, because I didn't see the trial decision, but the judge, it was one of the things that the judge claimed to have considered.
Okay, so the question we do have here is, how did the judge permit that? Yeah, I agree. That seems really unfair. So how did the judge permit
You would have
that?
to ask the judge, because look, judges have a tremendous, and I think this is anywhere you go, judges have a tremendous amount of latitude in how they run their courtroom.
Okay.
Right? In terms of keeping a calendar, keeping a schedule, keeping people on track. And in this case, the judge, when Mindy came and said, hey, can I have some extra time because I want to get this testimony in, the judge decided that on balance, it wasn't necessary. And the judge wanted to push forward and didn't want to delay things, and decided they were going to move forward. So that's up to each and every judge how they want to run their own calendar.
So another question that's come in that was on my mind too is, so maybe I don't fully understand what the difference between testifying and a report is. Like, I guess I didn't realize that was a thing that could be different, and then like you said, because we don't know if the judge took the report into, so can you maybe share the difference between when a report is submitted and when someone's called in to testify, and what the difference between that information is? So
a report is going to be a written report, right? It's gonna detail not just the conclusions that the evaluator has come to, but all of the work that the evaluator did, all of the things all the people that the evaluator talked to, all the interviews they had, all the documents they reviewed, all of the testing they may have done of either the children or the parents, all of that. It's going to be it's in very, very minute detail, ideally, right? That you can literally go through that report,
okay,
line by line, and say, okay, here's what they did on this day, here's what they did on this day, here's what they took from that, here's what they took from this. The reports are kept by design, kept very secret.
So that's what I was going to say. Did both Mindy and Israel see the report?
So they probably did see the report. Mindy must have, right? Because Mindy clearly thought it would be good to get the testimony. Okay. I guess by the way, it's also possible that Mindy thought it was really bad and just wanted the opportunity to sort of defend herself against the report. But that's also a possibility. I assume it was good just because of if you look at the implication of the decision, but it's not said there explicitly. But they're kept very secret. In fact, for example, if I have a copy, I can't make a copy for my client and say, okay, take this home. I can't email them a copy. I can't we are there, before it's changed a little bit now because of COVID, but before that, you weren't even supposed to have an electronic copy at all. You went down physically with a lawyer or with somebody who had signed a paper on behalf of the lawyer and literally picked up a physical copy and brought it. And you could review it in your office. So they're kept very secret. So it's not necessarily something that's going to be just sort of like out hanging in the courtroom.
Okay.
But that's the report. And oftentimes a report will sort of function as the evaluator's opening statement, if you would, like the first thing that they would testify about. They don't necessarily need to completely repeat themselves because the the report is there, but the testimony, when the live testimony, the parties would have a chance to cross-examine or to ask more questions, to follow up, to dig a little deeper, right? The report is it's what the evaluator thought was their views and this and that and the other thing, and sometimes you're going to want a chance either to bolster that by sort of going through it a little bit, maybe getting a little bit more detail. Oh, so you say that my adversary's client had, or the other party, you say that they have an anger issue. Can we talk a little bit more about what you mean by that and how you came to that conclusion? Or you might want to challenge it. Oh, you said that my client has an anger issue, but let's talk about that. The only piece of evidence that you cite for that is that because one time, when he dropped a hammer on his toe and he yelled really loud and, he swore. These are not real examples of, obviously, but that sort of thing. So there's the report is valuable, but live testimony can also be valuable.
Other question. Do we know if when a judge orders a forensic evaluator, are they ordering a report and testimony, or are they ordering one or the other? Like, is that an explicit part of the order?
They'll always order a report.
Always a report, but they don't always order a report.
The report is what they're ordering. But sometimes maybe neither party wants their testimony. Maybe both parties are willing to say, look, we'll rely on the report. We'll use the report we don't necessarily want. But it's more or less implied that, or expected, that if there's a report and there continues to be, right, if that doesn't cause a settlement or some sort of agreement, or if it's particularly contentious, it's expected that the forensic evaluator is going to testify.
Okay. And then there's, it sounds like you sort of covered this. The question was, could it be that the report was bad for Mindy and she wanted the evaluator to testify so that she had her chance to cross it?
Yes, like I said, I'm reading an appeal, so you're not always getting the full color. The sort of the implication when you read it, at least the reading comprehension I got, it seemed like it was good for Mindy, but it's possible that it was because it was bad for Mindy and it was just not necessarily.
Okay. So here's what I sort of feel. Like if the forensic evaluator, if the judge would have expected the forensic evaluator to testify regardless of the payment, then the way this whole case turned out, I think is ridiculous. And there was another question here. Couldn't the judge just say, if you don't pay, you'll get some sort of negative consequence? I'll award custody to the other parent. I'm
not sure they could say, if you don't pay, I'll award custody, but a judge can definitely say, if you don't pay, first of all, maybe it's important to note, expert witnesses, unlike regular people, right? If I witness something, if I physically see somebody, like if I saw a car accident, I can't say, well, I don't want to testify unless you pay me. Mm-hmm. Expert witnesses don't work like that. Expert witnesses are allowed to say, I won't testify unless you pay me, right? Like, I can't go to some random, let's say I got injured and I have a personal injury claim. I can't go to some doctor and say, well, I'm subpoenaing you, so now you're going to have to examine me and testify about my injuries, even though I don't want to pay you anything. Right. So they are entitled to say, unless I get paid, I don't want to testify. But what the thing you said, a judge could say, look, Israel, you're obligated to pay this. And if you don't, I'm going to assume that the reason you don't is because you're afraid of what's going to happen if she testifies. And therefore, I'm going to do what's called, I'm going to make a negative inference against you. I'm going to infer that her testimony would be bad, and I'm going to make my decision using that inference. Now, if the judge were to just say, on that basis alone, I'm going to throw the kids over to her, I think that would probably be too far. I think because the judge has to look out for the best interest of the children.
Right.
And just saying, well, this one factor is my entire decision, probably wouldn't satisfy that. But yeah, judges have a lot of, like I said, judges have a lot of authority to direct parties to make sure that they do what they're supposed to do.
So that's what I think should have happened. It just seems really unfair that by not paying or by stalling the payment, it seems as though Israel was keeping something from being exposed. And that I feel like the appearance of that is not fair. And therefore that should have happened. That's what I think. So I guess the decision was, should it be redone so that the forensic evaluator can testify? Yes.
Okay.
I think yes.
That is how the appeals court decides.
Woohoo.
Not quite for the reason that you said. They don't look at what Israel did in such a negative light. They don't really think about it that much. But what they say is, look, there's two issues here. The first and most important issue is that the forensic evaluation is really important.
Okay.
It's really important. It's something that we really want judges to consider. We really want them to have a chance to look through them and to talk to these evaluators and to make sure that the evaluations are good and have those really tested. And that didn't happen here.
Okay.
And second, the reason it didn't happen wasn't Mindy's fault. Okay?
Okay.
Right? So it's not that Mindy made choices that sort of deprived herself of the opportunity to have the testimony. It's because of something Israel did. So if it had been Mindy who hadn't paid, it's probably a different result.
Because of the fact that Mindy then wanted to stop. Okay.
Correct. Because Mindy was the one who objected. Mindy was the one that said, I need this testimony, and didn't get it. But if it had been Mindy's fault, right? If Mindy had done something to prevent the testimony, then you're not going to be able to get away with, you made your bed. But that's not what happened here. The judge says, look, this wasn't because she delayed. It wasn't because, or the judges, the appeals judges, it wasn't because she delayed. It wasn't because she didn't pay. It wasn't because she did something wrong. It was entirely because somebody else did something wrong, and she shouldn't lose out on the opportunity to get that testimony.
Can I clarify something? Maybe I don't know if I'm using the right language, but it was Mindy that brought the case to the appeals
Correct.
court. Okay. Mindy appealed, that's why, whether or not it was her fault that it happened.
And Mindy was the one who wanted the report.
Right.
Claims to have wanted it, right? She's the one who's standing there in front of the appeals judges saying, if only I had gotten this, the outcome might have been different.
Okay.
Right.
All right. So we have another case though, right?
So we have another case. So this is.
So I was right the first one.
So this normally when we do two of these cases, I feel like it's sort of like we're taking it here and then we move it a little bit. This is a very different direction. So we'll see.
Okay.
Optimize.
Case number 2.
Case number 2. Today's second case is called Montoya v. Davis from Columbia County in 2017. Now, this is a very high conflict case with conflicting claims about alienation and each parent claiming the other is really the problem. So the court appoints Val as the forensic evaluator. Val meets with both parties. She talks with them a long time, and she prepares a report that says, basically, mom is the worst and dad is the best. Every problem is mom's fault. Nothing is dad's fault. He's perfect and she's the worst. The judge, in his decision, effectively says, okay, if you say so. And on that basis, he awards full custody to the father. He allows the father to relocate to North Carolina, and he suspends the mother's visitation. So the question is there anything wrong with what Val did? What about the judge?
Okay. Let me stop share. So we have this case where you have a forensic evaluator who meets with everybody, who talks with them, who does, in fact, multiple reports. It didn't say it in the video, multiple reports. And that person's conclusion, Val's conclusion, is that basically every problem in the co-parenting relationship is because of the mother, that every time the father has missed visitation time, it's because of something the mother did. Basically, the mother is a terrible parent, the father is a wonderful parent, and so on and so forth. And then you have a judge who looks at that report, looks at those conclusions, says, okay, and makes a decision on the basis of those conclusions. So what do you think?
I mean, I thought that was the point of the forensic evaluator. So I understand maybe the mom in this case trying to appeal because she doesn't like the decision and maybe saying that the forensic evaluator was biased or something, right? Like I can understand, like if there's a reason why she can argue that the forensic evaluator's evaluation wasn't correct, she should argue that, but I thought the whole point was, you told us at the very beginning, the forensic evaluator is a mental health professional who analyzes the parents' and children's needs and potential issues or challenges and is a neutral party. So why wouldn't the judge take the forensic evaluators, I mean, as part of the full package, right? Because now we've learned, this is episode 7, so 7 weeks of this, maybe not 7 weeks of all custody issues, but we've learned that custody issues are decided kind of holistically from a lot of different perspectives using a lot of different pieces of information, and that the judge is ruling on the child's best interest that we know sort of from the start is, at least in New York State, the belief is that both parents, barring other extenuating circumstances, having a relationship with both parents is considered kind of like the gold standard, right? So I guess in this case, we have to trust that the judge took this piece of information from the forensic evaluator, considered it with whatever other information he or she had, and made a decision. So I'm confused. I'm like confused what the question is.
So here's my question. So there's something I want to dig into. Is there a question that we should do first?
Related to the last case, but we'll go back to that one.
You said we have to assume.
Okay.
Why do we have to assume that?
What did I say we have to assume?
We have to assume that the judge took
because they're a judge. Because they're a judge and that's what they're supposed to do. Again, if mom, we don't know what mom's name is in this case, right? If mom in this case and mom's lawyer have reason to believe that the judge didn't, that would be, sure, go appeal. But given the information that we have, I don't have anything to like.
So I think I'm going to go backwards because I'd like to address that.
Okay.
One of the things about the legal system that we live in, right, that we operate under, and whether this is about whether it's a custody case, whether it's a criminal case, whether it's a contract dispute, whatever it is, right? We want to give people the ability to appeal, right?
Okay.
The ability to appeal is something that's really paramount. If I don't have but here's the thing, I can't appeal based on what's in the judge's head, right? I can only appeal based on what's in the records, what's written down, whether it's written down by the judge or written down by a court reporter taking down what the judge is telling them. Okay. So it's incumbent on judges to, and by the way, not to be perfect, not to do exhaustive, but to, as well as they can, reasonably can, explain the reasons that they're doing what they're doing.
Sure.
So that way, when an appeal court is looking at it, they can say, okay, this was right and this was wrong, right?
Sure.
If all a judge says is, you win, you lose. Okay, how do I as a parent go and appeal I lost?
Right. Okay, but you didn't. So is that what the judge did?
So I think, and in this case, the judge, as I said, basically says in their decision, this is what the forensic evaluator said, therefore this is my decision.
Okay.
So the court, the appeals court, looking at it, faults the judge and says, you basically abdicated your responsibility. You are the judge. You have the responsibility to consider everything. And the forensic is an important part of that, right? It's an important piece of the puzzle. But you still have to consider everything else. You still have to consider their testimony. You still have to consider any documentary evidence that you might have. And they looked at the record and they say, we can't see that this judge in this case did that. And maybe the judge in their head did.
Right, maybe
the judge in their head did. Maybe the judge considered it and decided it wasn't really super important. Or maybe the judge looked at it and decided, well, it comports with everything the forensic is telling me. So I'll just kind of say it's based on what the forensic is saying. But the appeals court says, no, you can't abdicate your role that way. You're the judge. You're the one who has to make the decision, not the forensic evaluator. The forensic evaluator will give you a recommendation, will give you ideas, will let you know, but it's up to you, the judge, to make the decision.
And you didn't document it.
And
so therefore we have to assume you didn't consider all of the information.
We have to give, because we have to give the parents that due process. Right? Because we can't make it we can't say if the judge got it right, since the judge didn't tell us all the reasons that they made the decision.
Yeah.
Second, going and sort of stepping back a little bit, because my first question was, did Val do anything wrong? And what the appeals court looks at it, the appeals court looks at the report and says, looking at what this evaluator said, how slanted this evaluator was towards the father makes us think that this was not an unbiased person.
Wow.
Okay.
Wow.
It basically they look and they think of all of these examples and they say, look, it cannot possibly be that every single thing was this mother's fault and every single thing was the father's fault. And in fact, there's evidence in the record to show that that wasn't the case. And when we look at a report and we see a forensic seemingly bending over backwards to try and explain away or justify anything that one party did, but not giving anything like the same sort of benefit of the doubt to the other party, it makes us look, doesn't necessarily, they don't accuse the evaluator of being unethical or of being bribed or nothing like that. It's just, we look at it and it does not seem like this evaluator, we can trust necessarily that she was being objective.
Sure. Because her role was to be a neutral party in her report, she should convey her neutrality as much as possible.
And really make, look, and really make sure that that as an evaluator, and I'm not an evaluator. Obviously, I'm not a mental health professional. It's not something I could do if asked to do it. But, it's one of the things, if you're a party, right? Let's say that you're a party or a lawyer and you get a bad one. One of the things you're going to want to look through and say, look, does this evaluator have the appearance of bias, have the appearance of being interested in one party winning or the other? And on that basis, on those two things, so they say, one, Val seems like she was biased. And then two, the judge basically took what Val did and just wrote it into the decision.
Wow.
We're gonna overturn it. We're gonna start all over. And by the way, there needs to be a new forensic evaluation.
Are there 3 forensic evaluators?
And they all vote together. No, there's not the triumvirate of forensic.
Last week.
But they send it back. They say we need a new forensic evaluation. We need to have a new trial. The whole thing has to start over again.
Wow. Okay, I have a few questions about forensic evaluators, and we can see if any other questions come in, and then we do have a question about the last case. But just out of curiosity for forensic evaluators, how do you find them? So if a judge orders one, do they say, I'm ordering a forensic evaluator, here's Val? Or is it a thing that like each of them go to Yelp and say like forensic evaluators near me?
So there's a panel, and the panel is basically people who have applied to be given this role and are known by the courts to be qualified.
Okay.
I don't know all of the particulars, but it's almost all psychologists and psychiatrists. So that's one way. And two, it's not that big a universe of people who do this and do it well. And so judges, I believe, and I have found, and for good reason, have people that they feel like they can trust, like people whose work product they've seen in the past and who have felt like it's been good. So you see a lot of the same usual suspects. It's I'm not sure what the exact number is. Maybe there's 6 or 7 of them who you see over and over and over and over again. And we as lawyers certainly have people, we have a sense of sort of the proclivities of them and, what we think about sort of how to look at what they're doing and whether we like dealing with them more or less. But it's not a huge universe of people who do it.
So if you were if one were getting divorced and they were ordered a forensic evaluator and, the recommended Val, so they could go to their lawyer and say, hey, what do you think about Val? Do both parties have the opportunity to agree or disagree? Like, can you say, like, actually, no, like, I heard on the street that Val's
look, you can always object to anything a judge does, right?
Okay.
Right? Like, that's, again, part of due process is the opportunity to be heard, right? So but in my experience, unless you have something real concrete, and I'm not sure I've ever seen it in my career. Maybe I'm sure it's happened, but unless you have something real concrete about bias, like, wait a minute, you appointed Dr. Aronson. I wouldn't say that. There is a Dr. Aronson who does this, but if you appointed Dr. Whitney Aronson, who is Dr. Reed, who is the lawyer Reed Aronson's sister, right? You would say, wait a minute, that's, but you would need something very strong, just sort of like, oh, well, in our experience, he or she is, mean to dads or mean to moms or, mean to kids or whatever. That kind of a general sense is not going to cut it with ejection.
So Dr. Whitney Aronson has a question. Do you ever hire forensic evaluators to evaluate forensic evaluators?
In fact, you do.
Really?
Yes. It is called a peer review. That's the term. And it's what it sounds like, right? You would go and you would look. Again, I'm a lawyer and I have some experience reading forensic reports, but that doesn't necessarily make me an expert, a psychological expert. So what you do is you go and you hire somebody, some other doctor, usually again, one of the doctors who does this, who's in that pool. And you'd say, hey, could you take a look at this and let me know if there's anything in here that strikes you as a red flag or that you think would be something that could be challenged either on cross-examination, or we might call you in and have you do it. Like I said, due process is about an opportunity to be heard and the opportunity to present evidence in your own defense and the opportunity to challenge evidence that's bad against you. And one of the ways you do that is with a peer review. Now, look, it's expensive, obviously, because these people are highly paid professionals. But it's something that you sometimes have to do if you really feel like, the forensic didn't turn out how you might want. Or if you anticipate it, you could always get somebody in advance to sort of be like, hey, be ready, because this is coming down the pike and we have reason to think that it's not going to turn out well for our client.
That's really interesting. How about how does one, you might not know the answer, but how does one become a forensic evaluator? Do you know if they're practicing regular psychology or psychiatry on the side, like with patients, and then sometimes they're called in to be a forensic evaluator? Or is it something you do all the time?
I believe so. But yes, they are, for the most part, child or developmental psychologists. That's sort of their specialty. And they also do other things. They also do counseling. They also do those sorts of tasks. But my understanding is that for the people who do this, it's a big chunk of their practice between this. And we'll talk about parenting coordinators, being a parenting coordinator. We're going to talk about that next week. That's a different kind of role, but they'll often do that, that sort of thing. So they are all practicing mental health professionals. I think the degree to which this is sort of now their business it varies from one to one.
So I know that we're a part of this series where we're talking about the cast of characters in custody cases. So that obviously implies that we have children at stake. But are forensic evaluators ever ordered in cases without child custody? Would there ever be a reason, if it's because it's giving, ownership of something that's important, that they say?
So I've never seen it, and the regulation that creates, in New York at least, doesn't provide for it. There are forensic evaluators in other kinds of cases. Okay. So let's say that you have a relative who you think is a danger to themselves, right? You want to get them not committed. That's not really what happens anymore, but you want to sort of say, look, this is a person who's in quote in need of supervision, right? This person needs somebody who can look out for their interests because they have a mental illness or they have maybe a severe physical disability, something like that. There might be a forensic evaluator in a case like that. Okay. But if you're talking about just, two people are getting divorced and they're fighting over money, there wouldn't be a forensic evaluator in a case like that, because ultimately it's not really part of the calculation.
Okay. So I'm not sure if there's any other questions specific to this case, but we did have one question going back to the first case that we did with Mindy and Israel, just to clarify. So you shared that the appeals court said that they need to be able to hear the testimony of the forensic evaluator. So the question was, do they have to do another trial?
Yes, they ordered a new trial.
Is that with a new judge?
No, they ordered they allowed the same judge. So sometimes when you go up on appeal and it's returned, you might say, look, the reason that let's say that the issue was the judge was biased, right? The judge was didn't just make a mistake, but seems to have it in for my client.
Right.
In that case, the appeals court might say, look, we're going to reassign this to a new judge on retrial. But that's the exception, really not the rule. Okay. The general view is, look, we've got a judge who knows this case, who knows these parties, who's dealt with this. It's going to be much more efficient to go back to that same judge who just maybe made an error. Look, or by the way, sometimes you don't know what the law is, right? The law, you're making new law, right? We're not necessarily going to say, well, we need to have a brand new judge just because this judge, didn't predict how we would rule on this particular question of law.
Wow.
So normally you'd go back to the same judge.
Okay.
But if you can say, look, given what's happened, given the animosity in this case, given all of that's gone on, we really need a new judge, then you might get one. Or of course, sometimes judges retire, sometimes judges move on to different things, so that then you might get a new judge, but generally you'll go back to the same judge.
Do we actually, I would think maybe this question could apply to both of the cases we discussed today. Do we know what happened in the new trial?
So the first case, the decision was just from June of 2020. So obviously we're not going to have known that's not all going to have happened yet. And I don't know what happened. There's no, look, I'm working off of, I intentionally avoid cases that I have had any involvement in or my firm has had any involvement in. So I'm just working off of written decisions, and usually those are from appeals. So you don't necessarily get to know, unfortunately. But no, so I don't know what ended up happening on that retrial. It's a cliffhanger. If anybody knows Ms. Montoya, maybe you can ask her.
Don't go around asking everybody named Ms. Montoya, please.
Unless she looks like a doodle drawing, then that's probably her.
Unless she looks like Reed's doodle drawing. Yeah. So I know I learned a lot. I before today had no idea that there was even such a thing called a forensic evaluator. So we can see if there's any other questions that come in.
If not, no. Look, I think we're going to leave to another episode the kinds of things that forensics and experts generally are supposed to consider, because that's a big topic and a interesting issue of evidence and due process and all those sorts of things. But we're at about 45 minutes, so we'll leave that longer topic to another episode.
What should people do? So if they have questions, but they're either not watching this live, or we're about to wrap up and maybe the question isn't going to get under the wire, what should they do?
So you can write me. You write the show at unhitchinghour@gmail.com. They're open 24 hours, as email
is.
You can always catch, if you missed all or part of this episode, you can always catch it. I think it replays on Facebook, and you can also go to our YouTube page. All of our episodes get posted there within a week. And we do a little editing, so maybe they're even a little snappier. So you can always check out there. You can comment on my YouTube page. Please head over to my YouTube page, subscribe. We're almost up to 5 subscribers. So we're really moving up and moving and shaking in the world. But seriously, thank you all for joining us. I think that'll be today's episode.
So who are you?
So I am Reed Aronson. I'm a matrimonial lawyer here in New York City.
And I'm Vanessa Aronson. I am not a matrimonial lawyer, but I'm married to one.
And this has been the Unhitching Hour, how the law works when your relationship doesn't. Thanks, everybody. Bye-bye.